I think it's going to go into the COBRA site. And what that video does is it takes you through the act section by section. So we won't be doing that today. What we will be doing is we're going to be doing more of a Q&A with the panelists. And what's important on the Q&A is if you guys can please ask questions specific to your industry, specific to your particular case. Also be mindful of the fact that if you want to have a one-on-one discussion in relation to your particular company and the circumstances that you find yourselves in, you can arrange that with COBRA. It's part of the pro bono service. You can have one meeting, you can have 10 meetings, whatever's required. I'm also over the moon to announce a new partner who've just recently joined COBRA. It's R&B Ventures. They've come in again to contribute, collaborate in relation to finding the problems, finding solutions to the problems rather. And yeah, so welcome on board to R&B. That's fantastic. COBRA is certainly getting stronger by the day, and we're here to help. So we'll start off by throw a question out to Peter. Peter, I think just to open up, if you can take us through what's meant by financially distressed.
Good morning, Maurice. Morning, participants. Financially distressed in terms of business rescue is laid down in Chapter 6 of the Companies Act, and very simply it says if a company decides it cannot pay its liabilities as and when they fall due in the next 6 months, then the directors should be considering rescue. The Companies Act obviously has an older provision in Chapter 4 on what financial stability is when you're doing the financial stability of a company. And the only difference is that the directors have a longer period to decide. It's a 12-month period. But under business rescue environment, it's a 6 months period.
Yeah, and I think what's important to mention is that, I mean, most businesses are financially distressed at the moment simply because of COVID. I mean, it's a very, very low threshold. It's just if there's the exact wording from the Act is with reference to a particular company, and incidentally that includes closed corporations, if it appears to be reasonably unlikely that the company will be able to pay all of its debts as they become due and payable within the immediately ensuing. So it's just reasonably unlikely. The test the threshold isn't that high. So when you're financially distressed, Ian, once the board decides that, okay, there's definitely the circumstances are that it does appear reasonably unlikely because of COVID, what then?
Then, Maurice, the board has to, by law, take a decision as to whether they're going to put the company into business rescue or not. The test for business rescue is A, financial distress, and B, a reasonable prospect of returning the company to a solvent going concern, or the prospect of putting the company, of giving creditors a better return than they would get in a liquidation scenario. So the board is obliged by law to meet and to take a decision as to whether they are going to put it into business rescue or not. If they decide not to put it into business rescue for whatever reason, then they're obliged in terms of Section 1297 of the Companies Act to notify all affected persons of the fact that the company is in financial distress and to give reasons why they're not putting it into business rescue. As you can imagine, that's quite a big thing for a company to have to do. But unfortunately, that's what the law says, and that's why it's very important to consult with a business rescue practitioner or a turnaround expert for them to advise you what to do in that particular situation.
Yeah, I think so. So this is where COBRA comes in, because historically, if a company was financially distressed, they'd be obliged to put it to a vote. And in terms of the section which is on the screen, you'll see one sub 7. You'd have to then, if you didn't vote in favor of business rescue, you'd have to inform employees and, as Ian said, creditors. Now, and you've got to inform them also as to why you didn't vote in those circumstances. Now, what COBRA does is it gives you that reason. you can quite easily say then to your creditors, look, we haven't gone into business rescue because we've gone into COBRA, and we're inviting you as well to participate. The idea with COBRA is that you do not go into business rescue. The first port of call is for the COBRA mediators to mediate with your creditors payment arrangements, regard being had to their cash flows and your cash flows. So if you think about it, if you were to take the Spaza shop to be right at the bottom of a cascade and the bank right on the top, what you'd want to achieve through COBRA is that every payment made or all the liabilities are just sufficient to keep every business alive all the way up to the bank. And we know that the banks have come to the party. So
that's correct, Maurice. There's a lot we can do before we put a company into business rescue. You very correctly said that business rescue is, we try to avoid it at all costs. And, we tend to do that in our, before we formed the COBRA initiative, that was the way that we worked. That's the way Schindler's and Engaged both worked. And each company needs to be considered very, very carefully. And, all the nuances around a particular company need to be considered very carefully before the business rescue decision is taken. And the aim of COBRA is really just to take the business rescue decision if there are creditors who don't want to negotiate anymore, can't negotiate anymore, and are threatening liquidation applications and so on. But yeah, the aim, it's very important to note that the aim is to keep it out of business rescue at all costs.
I think let's move on to that. So when a company is in business rescue and you put a company into business rescue by a simple majority at a board level or by way of a court application, what kicks in is a moratorium. And the moratorium is against legal claims against the company. So the moment the company goes into business rescue, the moratorium kicks in. So the moratorium achieves an equality in bargaining power, because what normally happens is you have a creditor who's bashing down your door, who's aggressive, who says pay, 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 or I'll liquidate. So there's the duress, the economic duress. I will liquidate unless you make a plan. But you can't make a plan, but you do know that, as an example, your cash flows will allow for you to settle the debt in 3 months. What you do in those circumstances, you try and reason. COBRA will try and reason with the creditor, and if the creditor gets heavy-handed, then COBRA says, we're putting you on a pro bono basis into business rescue, and then the negotiation proceeds, where the creditor doesn't have the option to put the company or sue the company. What the creditor can do is still apply for the company's liquidation, can convert the business rescue into liquidation. That's by way of a high court application, and generally only happens when there's an abuse by the company. So in other words, the business rescue is just there to defeat a claim where there's no defense, or the company is hopelessly insolvent. Now, I just want to conclude an important aspect of that, and this is one of these takeaways that you have to remember and make a note of, and that is the business rescue practitioner does not have, has to suspend all contracts the moment he or she is appointed. Reason being, for instance, if there's a lease agreement and the business rescue practitioner doesn't do that, and the landlord cancels the lease post-business rescue, the landlord can still evict in those circumstances. So obviously all the engaged guys know what they're doing, but there are business rescue practitioners out there who are new.
Okay, looks like we've lost Maurice. Yes, so I think
all your creditors, yeah.
Sorry, we lost you for a moment, so I was just taking over there for a second.
No, not again. Where did you lose me up to what? When?
You said there were business rescue practitioners who are new and might not know what,
Yeah, so on that score, what I recommend is you have a list of all your creditors, the amounts owing, you give it to the business rescue practitioner so that they can immediately address those creditors and let them know, or the counterparties to the leases or other contracts, and let them know that the contracts are suspended.
It's better for a business rescue practitioner to suspend more contracts rather than not suspend any. once you suspend all the contracts, then creditors will obviously approach you and want to talk and negotiate, and then it's easier for it's a better situation to be in when you're then forced to perhaps put some contracts back in place, as opposed to having the risk that you might be evicted as a result of the lease not being suspended.
Yeah, thanks. Peter, employees and directors, the moment you come in.
Maurice, yes, the practitioner takes absolute control of the business. He's an appointee of court. He's in a supervisory position over the board, so his decision is paramount. With Engage, we have a principle of working together with directors rather than against them. It certainly makes sense. Have a collaborative approach rather than an acrimonious approach. The directors remain on the board, unless they resign, of course, with full fiduciary duties, as exactly the same as the practitioner will have. So the normal fiduciary duties that a director has vis-a-vis the company do not change. He's not relinquished of those duties. So that's an important point. Directors often think, sure, I'll get away with it then, somebody else is now going to carry the problem. Not the case. But obviously, ultimately, the practitioner has to decide on what's going to happen with the company. The practitioner can hire and fire. He can appoint anybody to assist him in the rescue. He can appoint staff to the company. He can appoint consultants to assist the rescue itself. He cannot remove a director without going to court. But the normal rules in the Labour Act apply. So Section 189, reduction in staff, all those principles still apply and can be carried out whilst under rescue. The staff are, because they're classed as affected people tend to forget that, but your staff are at any one time creditors of the company. So they're always owed money by the company, whether that's for work already performed in the month or for accrued leave, bonuses, etc., etc. So they have a say in the rescue. There's a specific section in the Act which requires the practitioner to advise the staff of the rescue and their obligations and rights. So it is a discussion with the staff, and I think, Maurice, as you were saying earlier, it is quite critical that the practitioner can manage the staff to make sure that you don't lose everybody. When things are tight for one company but the economy is buoyant, as we all know, the good staff tend to disappear quite quickly. So it is quite a challenging point for the practitioner from a rescue point of view to make sure that the good people stay on board.
Yeah, sure. And I think what we've encountered in these webinars is there's quite a few people who've personally funded the salaries. So the income has dried out, and what they've done is they've gone into their personal savings and said to themselves, well, let's put some money in here to keep this going, knowing that the business will be okay, let's say in 3 months' time or whenever. So when it comes to putting that money in, Ian, talk to us.
Yes, thank you, Maurice. If you are going to take the business rescue decision, it's better to put the money in after the company has gone into business rescue, because that affords you priority in terms of repayment of that amount. It's known as post-commencement finance that you're putting into the company, and post-commencement finance is an important part of most business rescues. If you put in money into the company once it's gone into business rescue, then that post-commencement finance that you put in ranks right at the top of the repayment, what we call the waterfall under business rescue. It ranks just below the payment of the practitioner's fees and disbursements. Should the company, for any reason, go into liquidation at the end of the day, then if you put money into the company and you've secured that debt via an asset in the company, then your debt in terms of the waterfall ranks right at the top. So company goes into liquidation. In business rescue, the business rescue fees and disbursements to the practitioner rank right at the top. Once it goes into liquidation, in terms of the Dina judgment, which was ruled on about approximately a year and a half ago, then the business rescue practitioner's fees and disbursements fall to the bottom of the payment waterfall, but any secured post-commencement finance creditor still ranks right at the top if that company is in liquidation. It ranks before SARS, it ranks before other secured creditors and so on. So if you're going to put money into the business, the recommendation is to put it in after it's gone into business rescue, and to make sure it's secured by an asset that's in the business.
Yeah, so business rescue is actually appropriate just for the purpose of PCF, post-commencement finance. So even if creditors aren't bashing on your door, it's worthwhile to rather invest in those circumstances, post-business rescue. We've got a question here: how likely are landlords to start proceeding or attempt evictions during this lockdown period? Well, I'll answer that. I'm a landlord myself, and I can tell you the first thing I did is I wrote to all my tenants telling them, listen, show me that there's been a drop in income, and I will make a plan by dropping the rentals to accommodate the drop in income. And then the idea is to amortize the shortfall over the balance of the lease or to extend the lease. So I think it's unlikely that landlords will be getting heavy-handed, because they know that business rescue is just going to put a stop to any of their claims, and they're going to have to negotiate. Let me mention a business rescue that we did at a restaurant in Camps Bay. At that what we did there is we put the company into business rescue. It was not coping because the weather was terrible and it was winter, and it just was in negative territory. Put it into business rescue, went straight to the landlord, and the landlord was reasonable from the start. The landlord saw what was happening. The landlord trusted the business rescue practitioner because the business rescue practitioner wasn't conflicted, and the landlord agreed to a remission of rental, and we pulled the company out of business rescue and carried on trading successfully. So the answer is, I believe in this climate, far less likely than a couple of months ago.
Correct. I think there's going to be a lot of understanding during the lockdown period. But at the end of the day, it's going to come down to, a couple of months down the line. It's going to come down to how much pressure the landlord is under himself, from his own creditors, and people and this is the importance of the whole COBRA ecosystem, because landlords will give relief to tenants to the extent that their creditors are giving them relief. But if their creditors start coming down on them, then they're going to have no option but to start coming down on their tenants. So it's a vicious circle, and it needs to be managed very carefully, and hence the reason for the COBRA ecosystem that we've created.
Yeah, there's in our minds, there's no reason why businesses should go into business rescue if the creditors are reasonable, particularly landlords. And I think they are being reasonable. The attitude they should adopt is, you cannot suck blood from stone. So what's the point? I don't know if we went into much detail, but did we, Ian, in relation to the first meeting with the employees and how that works and the timing?
No, we haven't done that yet, Maurice. So should we check that briefly? Okay. So a company goes into business rescue on day one. The decision is taken. It's simply a case of completing some resolutions and filling out some forms and submitting them to CIPC. The moment that forms are submitted to the CIPC, the company is in business rescue. It's then the onus is on the company to, within 5 days, appoint a business rescue practitioner, and within 5 days, they also need to notify all creditors of the fact that the company is in business rescue. So that happens on day 5. The submission that needs to be made to the CIPC for the appointment of the business rescue practitioner is also just a form that needs to be filled in, and the business rescue practitioner needs to write an acceptance letter for the appointment and send that to CIPC as well. So that happens on business day 5 after the company's gone into business rescue. And then 10 days after the practitioner is appointed, he needs to hold 2 meetings. One meeting with creditors and the other meeting with the employees. And the purpose of the creditors meeting and the employees meeting is basically for that business rescue practitioner to express an opinion as to whether he believes there is a reasonable prospect of saving the company. In other words, of returning it to a solvent going concern, or of giving creditors a better return than they would get in a liquidation scenario. So that's the only purpose of the first creditors meeting. As you can imagine, the business rescue practitioner has only been in place for 10 days. He's had a very limited amount of time in which to understand the business in its entirety, understand the challenges of the business, understand whether there is in fact a reasonable prospect of rescuing the company. Obviously, the meeting with the employees needs to be handled in a very sensitive way. People's jobs and people's lives are at stake, and it's very important we always say that the rescue practitioner's qualifications are so much more than just being a chartered accountant or a lawyer. There's really a very wide skill set, which includes having the EQ to be able to manage situations like that. Maurice, do you want me to carry on, or should I explain the whole business rescue process just very quickly in a nutshell?
I'll just put this on the screen, just also mention that security holders, so shareholders, also have a right to notice of each of the court proceedings, all decisions, meetings, and other relevant events concerning the business rescue proceedings. Participate in any court proceedings and formally participate in the company's business rescue proceedings to the extent provided for in the chapter. Now, that would mean that security holders actually have greater rights in the context of a business rescue, as opposed to the rights that they enjoyed outside of business rescue. So, yeah, I just want to point that out. Carry on.
Very important to notify the definition of an affected person. An affected person is something that comes up all the time. An affected person is somebody who will be directly affected by the business rescue and by the impact of the business rescue. And affected persons are generally always creditors, employees, and shareholders. So the people for whom the outcome of the business rescue will affect their pockets at the end of the day, and their livelihoods. So yes, let's just jump back into the process. So at the end of, 10 business days after the appointment of the practitioner, we hold those meetings to express whether there's a reasonable prospect of saving the business or not. The business rescue practitioner then has, from the date of appointment, he has 25 business days in which to compile a business rescue plan and to publish a business rescue plan. So 25 business days, or 5 weeks after he's been appointed, he needs to publish a business rescue plan to all affected persons. In other words, all creditors, employees, and shareholders. And then the second creditors meeting is held 10 days after that for the plan to be voted on. Now, the business rescue plan covers section 130 of the Act, 150 of the Act covers everything that needs to be in a business rescue plan. It's basically everything that contains everything that a proper business plan would cover. It covers, there's the Act in front of us. So it covers complete list of the assets. It covers the list of the creditors and the various classes of creditors. The probable dividend that would be received by creditors in their specific classes if the company was to be placed in liquidation. Now, that's a very important calculation and a very important part of every business rescue plan, is what would the company get in a liquidation scenario? And what we typically do is we draw up a liquidation and distribution account, and we include that in the business rescue plan. We then compare that return, the plan then compares that return that creditors would get in a liquidation scenario to what they would get in a business rescue scenario. And obviously they have to, for the business rescue plan for the business rescue plan to have any hope of success, it has to show a better return for creditors than in a liquidation scenario. It needs to show the shareholders, it needs to show sorry, just go up a little bit there, Maurice. Let's go up to there. Complete list of the shareholders, and what the issued securities are. a written agreement as far as the practitioner's remuneration goes. Often a practitioner will structure a contingency fee as part of a business rescue plan. In other words, based on a real success event occurring in the implementation of the plan, the business rescue practitioner would earn a contingency fee. It's very important that that contingency fee is based on genuine success. We don't believe that the approval of a business rescue plan in the second creditors meeting is a milestone that can give rise to a contingency fee. Because that's not a milestone that is achieved in the implementation of the business rescue plan. Any contingency fee that a business rescue practitioner earns has to be linked directly to real turnaround results, and that's very important for companies to ensure that that their business rescue practitioner is only earning fees on that basis. And then, part A, section 6 says that a statement needs to be included. That's fine, Marie. A statement needs to be included whether the business rescue plan includes a proposal made informally by a creditor of the company. This is just to promote transparency. The business rescue process has to be an extremely transparent process. That's the only way it can work. Business rescue practitioner can't be making secret deals with certain creditors or other affected persons or whoever the case may be behind the scenes. That's why the Act is trying to promote transparency by stating that any informal proposals made by creditors of the company need to be disclosed in the plan. Okay, part B, it envisages the nature and duration of the moratorium for which the business rescue makes provision. In other words, how long during the business rescue will creditors not be able to take legal action against the company? The extent to which the company is to be released from the payments of its debts, in other words, in layman's terms, the haircut that each creditor will be taking, and if there's any proposed conversions of debt into equity. The ongoing role of the company and the treatment of any existing agreements, in other words, are certain agreements being suspended, and to what extent needs to be disclosed in the plan. The property of the company that's available to pay creditors' claims in terms of the business rescue plan. In other words, what non-income generating assets especially can be sold in order to start paying creditors sort of right from the word go. The order of preference in which the proceeds of the property will be applied to pay creditors if the business rescue plan is adopted. In other words, the waterfall that I was speaking about earlier. Benefits of adopting the business rescue plan as opposed to benefits that would be received by creditors if the company were to be placed in liquidation. We've already spoken about that. And the effect that the business rescue plan will have on the holders of each class of the company's issued securities. We've spoken about that as well.
Brilliant. Yeah. So, Peter, if you can just jump in, mindful of what Ian has taken us through, and just give us a practical example that you've been involved in where there has been a plan and it succeeded. So, not one of those that has failed. Just an actual company you dealt with.
The most recent one that I managed to take out of business rescue, it was a long saga. I was appointed in November 2015, and I took the company out of rescue in July of last year. There had been fraud. It was a financial services company. The directors had taken 275 Muslim Sharia investors' money and basically spent it on personal assets and assets that weren't necessarily going to generate a profit. As I think most people know, in the Sharia environment, you can't earn interest. It has to be a share of profits. So they used that together with a fairly senior religious man in the mosque to garner money from these people. It was quite a significant, about 150 million. And they were left with, thankfully, a undeveloped piece of property in a mining town in South Africa, which had been started. They started the development in 2004, and it had failed. So that's what I was handed with. So you've got to be quite creative with this. As Ian said, you know, generating returns for the affected people. Just one thing to remind everybody that whilst the shareholders are affected people, if you don't change their rights in terms of their equity, they don't have a say in the plan. As soon as you change the nature of the shareholders' equity, for example, converting ordinary shares into preference shares or something like that, or converting preference shares into ordinary shares, then you need them to say whether they're happy with the plan or not. With this one that I was dealing with, the property, I eventually found a developer, and we created a financial instrument for the creditors and ended up paying the investors out over a 3-year period and by way of a secured debenture. So if one looked at this company on the face of it, with the fraud, with the loss of cash that had leaked out of this business, it would have been an easy thing to say this is clearly a state of liquidation. I had an external formal valuation done from a liquidation point of view, and the assessment was that creditors would get 12 cents in the rand. As it is, they've received 100 cents in the rand at a 7% return, but albeit over a 3-year period. So it is a success. It was a difficult one. I had 2 bunches of creditors that were at each other's throats. I had a Mexican standoff in the process. I was having to comply with the FSCA, the FSB as it then was. And so it was a difficult rescue, difficult people to try and deal with all the creditors, get them all on board. Obviously, investors get very nervous when they think they're going to lose their pension fund. But yeah, in the end, I'm now friendly with a whole lot of Muslim people that I wasn't friendly with before this rescue, because we've managed to pull it off.
Brilliant. I think, yeah, I just want to mention that when one contrasts liquidation with business rescue, when it comes to those scenarios, very often liquidation is a better option when it comes to uncovering the frauds. So if there's an investigative element, a forensic investigation, you need to interrogate and you need to summons and you want to hold secret inquiries, those powers are given to a liquidator in terms of the old Companies Act, which has been incorporated into our law in terms of the new Companies Act. And over there you can have the armory given to a liquidator is significant. A liquidator can basically subpoena anybody. Doesn't have to do much in persuading a magistrate to do so. In fact, we're involved in a litigious matter where the liquidators just subpoenaed all and sundry without a proper basis. Those subpoenas have been taken on review, but the fact of the matter is the magistrate granted them in the first place. So, yeah.
There's just one thing to add there very quickly, yeah, is that you're 100% correct. The liquidator has the ability to summons and call for what is called a 417 inquiry, which is normally held in front of a retired judge. But beyond that, the practitioner does have an obligation to investigate anything that he thinks the management have been doing that is against the law. He's then obligated to instruct management to cease doing whatever they were doing, and then finally has to report it to the authorities. So in that process, as I did, I appointed a forensic auditor. He did his examination, we got the report, and because the regulator of this company is the FSCA, I reported it to them. I mean, one of the things that happened there is, of course, got sucked into the investigation of the FSCA, which obviously they had full summonsing ability. So it was an interesting one, because going down the rescue route, we still achieved, or rather the regulator achieved, the ability to summons and conduct their own investigation.
Yeah, great. Okay. How does, whilst you're on it, how does business rescue end?
Normally, well, it can end in a number of ways. The quickest one that's been the case by the courts is where normally the banks will bring an application to have it overturned because they feel that it is inappropriate and apply for the liquidation. And that's, I think you covered this, where an entrepreneur thinks it's all going to be fantastic tomorrow. He's got normally properties, the bank secured, and the bank believes that there's no point in trying to extricate value out of this over a period of time. So that can be very rapid in front of the courts. In the plan that Ian was detailing, you have a section in there where we would put an section in. It's not necessarily obligated in terms of the Act, but we put a section in on what constitutes substantial completion. Important word, that substantial, because it doesn't have to be tied up 100%. You can hand the company back to the shareholders as long as these mechanisms in place to make sure that creditors get their final payments. You don't have to have a rescue practitioner sitting around earning fees, and all that you are waiting for is the cash to come into an account to pay creditors. So substantial completion, we'll normally state what we believe substantial completion is. If there's going to be a compromise with creditors, it's to pay substantially that dividend, etc., etc. So you can lay that out in your plan so that it's clear to everybody. And Ian was touching on the point of, practitioners getting a contingency fee. A success fee for us would be once we've substantially completed and implemented the plan. Once that happens, the practitioner is obligated to file a notice at SIPC stating that it is complete, and the company is handed back to the owners. Two important things to remember there is if the practitioner can't, at any stage during the rescue, see his or her way clear to rescuing this business and achieving a better, or rather rescue it, or achieving a better payment out for creditors, i.e. better than liquidation, then he or she is obligated to put the company into liquidation. In other words, we thought it was going to be able to be rescued, but circumstances were such that it was not achieved. Then it must be put into liquidation. Yeah, I mean, I think
we often allow for a creditor's vote. We often put a vote. Well, we haven't fortunately had to do it many times, but we before taking the liquidation decision unilaterally as a business rescue practitioner, we would put the decision to liquidate or not to a vote of creditors, and that just helps to ensure that there's buy-in from a majority of the affected persons who initially voted the business rescue plan in to take the liquidation decision. You also just want to, in the spirit of transparency, ensure that people don't think that you as the business rescue practitioner have some incentive to put a company into liquidation. Therefore, it's good practice if you are going to take the liquidation decision to put it to a vote of creditors before doing so.
Yeah, thanks for that, Ian. And an important point there is the practitioner cannot be appointed as liquidator. The Act specifically excludes it, rightfully so. But the thing that Ian and I do of putting it to the vote to the creditors isn't actually a requirement of the Act. The practitioner can, on his sole discretion, put the company into liquidation.
Yeah.
I've got a question. Liquidity of small businesses hinges on the duration of the lockdown. Does the panel have any sense of how long this will be and whether it will extend beyond the 21 days? So from my view, and I've given this a lot of thought and done a lot of research, in my view, it's certainly going to be extended beyond the 21 days. And I'll tell you why. When the lockdown commenced, I think there were roughly, or the shutdown, there were roughly 50 cases, and we got into action. So that would mean, logically, that we'd have to get to below 50 or practically nothing for the lockdown to be lifted. And that's not going to happen anytime soon. So I actually wonder how long this is going to be, because logically it ought to be until there's not one case. And when will that happen? Only when there's a vaccine. And when do they say a vaccine is going to come about? They're saying 18 months. So I think that is the one aspect which I don't believe. I think a vaccine is going to come out a hell of a lot sooner than our 50 labs working on it. So yeah, hopefully
some very difficult decisions are going to have to be taken by the powers that be. Ultimately, they're going to need to weigh up the benefits or the detriment of the economy to the detriment of the health system and the people. And it's a very it's a very difficult decision they're going to have to make, because you're talking about lives, but they need to consider how many lives are going to be negatively impacted or lost as a result of the economic collapse that may follow a very prolonged lockdown period. Compare that to the loss of life and the infection rate should the lockdown be discontinued, or should the economy
we're about to announce a specific webinar that we're holding on Friday, which is going to be we're going to be dealing with restaurants and the hospitality business specifically. Because, I mean, if one thinks about it, because the future is so opaque, what business plan can one put together? When will these restaurants reopen? I mean, Peter, how would you deal with that in a business rescue when you just do not know?
Maurice, look, you know, there's an old adage, and of course it is 120% relevant in the current process, that cash is king. So one's got to try and conserve whatever facilities the company has. I mean, sadly so in the restaurant trade, that whilst the restaurant remains closed, i.e. sales are being turned off, is staff have to be laid off. I mean, that is the negative of all of this. However, you know, from a creative point of view, I am aware of a restaurant at the moment in Johannesburg that is producing food for delivery, and they're managing to get food delivered to people that order over the net. So you continue supplying your product that way. I don't know how easily that's going to be achieved with the full lockdown. But it's a matter of just, well, as Ian said earlier, you've got two major costs in a restaurant, your staff and your landlord. And it's a matter of negotiating quite long and hard with the landlord. And most landlords in a situation like this should be, not all of them will be, but they should be flexible. Bearing in mind, the landlord that's not flexible is the landlord that themselves are in difficulty, probably with the bank. So, you know, if they're having difficulty negotiating their creditors up the line, they're going to be less minded to offer concessions to their tenants. But yeah, it's a matter of cutting your cloth to suit. And that means, unfortunately, as I say, laying people off. If you can afford to do that. I mean, that's the other point. You can't, you know, start laying people off if you haven't got the funds to do it. Rescue, of course, will protect you from any legal action. But, you know, and as Maurice, you said right at the beginning, the important point there is to suspend all your contracts and then just cut it down into, you know, it's almost a dormant company during this period with hopefully some cash reserves in the bank account.
Yeah, I mean, one has to be creative, and I'm also wondering, you know, it's the difficulty, let's say, with restaurants and the hospitality businesses. If you don't know when the shutdown is going to be lifted, what does one do? I mean, does one start exploring another industry? Does one start you know, trying to find opportunities in something completely different? And I think that would be particularly difficult. I have a question here that I'll direct to Ian. I believe that some CIPC departments are not currently working during lockdown. How does that affect the timelines of business rescue?
So CIPC issued a directive just before the lockdown, Maurice. They said any section 1 to 9 activities that were that had been started but not completed would be allowed basically a break, a 30-day break or a 34-day break until the 30th of April to complete those activities. Now, the section 1 to 9 activities are the putting of the company into business rescue, the notification of creditors, the appointment of a business rescue practitioner. So any of those activities that were started but not completed can be the 34 days of the lockdown, or at least until the 30th of April would not be counted. So the process would be extended by 34 days. It's interesting to consider the position as far as putting a company into business rescue in order to prevent a liquidation application from happening. So as we've spoken about earlier, once a liquidation application has been made to liquidate a company, you cannot then put the company into voluntary business rescue. 99% of business rescues are voluntary, in other words, board decision. So we formulated the opinion, consulting with various experts from within the COBRA collaboration, that should a company be placed, should you place a company in business rescue by having sent the forms to the CIPC during the lockdown period, if a liquidation application then follows that, then the courts would more than likely recognize the company as having been in business rescue prior to the liquidation application having been made. However, companies can still make urgent liquidation applications during the lockdown period. So it's important if there is a threat of a liquidation, that a real threat of an urgent application to liquidate a company, that the company be placed in business rescue if it's appropriate prior to that happening. And that process of putting into business rescue is us sending the forms to CRPC to give effect to the same.
Ian, can I just add to that, because you're 100% right, but what SIPC has also done in that notice is stated that the rules in respect of Chapter 6 are non-dias. So in other words, there is no law. The law is not applicable. And that was for a period of up until I think it was the 15th of April. Ian, you'll correct me if I'm wrong. But up to the 15th of April, you cannot apply for business rescue. As Ian's explained, we did have an off-the-record confirmation that if applications were sent in, they would look favorably on it. We must remember that nobody can bring a liquidation application other than urgent if the courts are closed. So an urgent application, I would posit, are only going to be those cases where the shareholders are busy stripping, or somebody's stripping the assets out of the company during this period. And believe me, there will be some people who are trying to do that. And if that is the case, then obviously the creditors could bring an urgent application, because failure to do so would be a serious loss to the creditors. But the view is that an ordinary liquidation application is unlikely to be heard. And if it is heard immediately after the lockdown finishes and SIPC open up for business again, that, as Ian rightly said, we've been told they will consider applications that have been submitted during this period. However, obviously, needless to say, it hasn't been tested in the law. So we are in a little bit of unknown territory here.
I'm going to deal with two questions by Diane. I'm going to start with the first, which is very similar scenario in the tourism industry at the moment. The safari industry, no real question here, interested in the way forward. Now, this is really, it's off topic, but tourism was changing dramatically in any event. And quite a few companies involved in tourism, such as airlines, have started reinventing themselves in view of the fact that they've seen that exponential technology is really changing the world. And I'll just use an example over here that I've just pulled up. I'll put it on my screen. This article was prior to COVID. And you'll see the Japanese airline industry wants robots to travel in your place. Why leave home for a long, tedious trip when you can send a robot surrogate? So this is an airline actually cannibalizing itself, recognizing that things are going to change. So this is happening beforehand. So the answer here, and I've seen it because you get Londolozi trips, and you can have live safaris on the net. I think the answer here is urgent reinventing. I mean, it was already happening, but now this has catapulted the tourism industry into a whole new urgent area where things have to be, the models have to change.
Absolutely. Sorry, Maurice, just talking about models changing, one of the things we always, or most of the time in business rescue, start putting into place is trying to convert companies with high fixed cost bases. We often try to convert their cost bases into variable cost bases as much as possible. Now, when a crisis like this happens, the companies with the high fixed costs are the ones that suffer by far the most. And that's one of the reasons why the hospitality industry is in so much trouble right now, because your staff costs are typically recognized as a fixed cost, and your rental is a fixed cost, and those are your biggest expenses. So as far as possible, what's going to have to happen is companies, or what we predict happening is that companies will move onto a much more variable cost model than they were on before as a result of this crisis. And our intention is to help companies to do that. Because the companies that currently run off variable cost models, where, in other words, where their cost base is directly linked to their revenue, are the ones that are suffering less at the moment than the ones with high fixed cost bases.
To go to the second question by Dan that I was going to answer, and that is, can salaries be legally reduced during lockdown? So the rights of employees remain exactly the same. They remain intact, and sections such as 189 of the Labour Relations Act dealing with retrenchment continues to apply. Now, section 189 deals with retrenchments, but what it also deals with is the possibility of a unilateral variation to an employment contract. A reduction in salary is a unilateral variation to the contract. So what one has to do is consult with employees in terms of section 189, which is a retrenchment. And as an alternative to a retrenchment, you can offer a reduction in salary. However, if the employee refuses to take it, then you'd have to pay the employee severance and offer a retrenchment. What we find is happening is employees are appreciating that they need to agree. So you can vary an employment contract by agreement. So what we're finding is the consultative process is happening very, very quickly. Historically, it takes time, but now it's curtailed because the reasons for dismissal are common cause. Everybody knows why the dismissals are being proposed. It's because of COVID. But you need to get the employees' buy-in. Now, on that score, if you want us to assist through Zoom, speak to your employees to explain to them what is required for your business to survive, we'll do that quite happily. Just bear in mind, as for COBRA, you don't have to just jump into the ecosystem. If you want us just to deal with the employees, or you just want us to explain the legal landscape, we'd be more than happy to. I see there's a question by Raymond, but I see there's quite a bit of quoting.
Should I cover that quickly?
Yeah, please.
I think Raymond's referring to the legislation that was promulgated, which affects the Competition Act, with Section 3 and 4, or 4 and 5. Dean, you might be able to comment on that more extensively, but essentially what it does is it allows retail businesses of certain suppliers, I think the soft furnishings, clothing industry, the restaurant industry, and there was one other, have been given a concession whereby they can negotiate with their landlord for preferential terms. Under the Competitions Act, that would be illegal because it would show as anti-competitive behavior within a retail shopping complex. So individuals can negotiate with the landlord for a rent holiday, for example, or a reduction in rental without contravening the Competition Act. It doesn't actually dictate that the landlord has to negotiate with the tenant. So I also, when I first read this piece of legislation, I thought it was going to help by forcing landlords to go into a negotiation, but it doesn't. It merely means that by doing so, they're not contravening the act. And that's my reading of it. I mean, I'm not a lawyer, I'm an accountant, but if there's anybody else that's got further info on
I think the question relates to why is it only limited to clothing and restaurants in terms of the definitions of that regulation. That's really what it defines and deals with. And I'm actually not quite sure. I suppose maybe because those are one of the biggest and identified as the base that need to be protected during this time.
Well, I think those are the ones that are directly affected by the lockdown, Dean. However, there are, that was my take from it when I read that ruling or that directive. But there are a lot of other businesses that are also directly affected by the lockdown. I mean, they obviously didn't include supermarkets because supermarkets can more or less carry on trading as normal. But there's a ton of other businesses
hairdressers aren't covered, are they?
Personal care services mean retail outlets providing personal grooming services such as hairdressers, health and beauty salons. Yeah. So I think they would be.
Okay, I just want to call for any further questions. And I just want to use this opportunity to show the notice, the COBRA notice to creditors that's being used to avoid you going to business rescue. so you get a better understanding of what we're doing. This is the notice that you would send to your creditors. It's addressed by us. We have joined the COBRA ecosystem. The COBRA War Room is a pro bono service to businesses that need urgent assistance due to the business's financial distress caused by. We're obliged to consider. Now, remember, we dealt with that. You have to consider putting the company into business rescue, and you vote against it. You have to give reasons. Now, here you go. Here, due to the business financial distress caused by COVID, we are obliged to consider putting the company into business rescue in terms of 129 of the Companies Act, which you've decided not to do due to the fact that we've joined the COBRA ecosystem. Please join the COBRA ecosystem. They'll assist you in mediating a financial arrangement between you and any company within the ecosystem so as to ensure our continued survival. The idea is that they attempt to strike a balance between the creditor and debtor. So that is the idea, to avoid a business rescue, and business rescue would only be employed if the creditors were unreasonable. I'm not sure if are there any further questions? No. If there are, please address them now. Otherwise, anything else that the panelists want to add?
Maurice, just to say, I mean, we obviously, because of this systemic risk that's hit us, you would assume, and we were talking about landlords earlier and restaurants, you would assume that most creditors are open to negotiation because they'd rather get some money rather than nothing. But as I said earlier, we must just be very cautious that your creditors aren't themselves facing huge pressure, because then decisions tend not to be taken in a sane way. You're under pressure, your back's to the wall, so you're just going to grab, and if that means that you can apply for liquidation or try and get 100% of what you owed, there could be an acrimonious environment as a result. I suspect a fair amount of litigation is going to occur after this lockdown or after this period of uncertainty, which is sad, because by cooperation, and I think we've all agreed that that's how we operate, by cooperation one must surely be able to get a better result than in an acrimonious environment.
That's so true. There's so many aspects that need to be considered, and so many things that need to be weighed up. And one of the important things when negotiating is to put yourself in your opposition's shoes. So if a creditor, or if you as a tenant are negotiating with the landlord, you've got to consider things like, for example, if he does end up kicking you out, if he does manage to evict you, what is his likelihood of replacing you as a tenant? And in the current environment, and in the environment that's likely to follow within the next 6 months to maybe even a year or more, is that there'll be very few tenants willing to take your place. So these things need to be considered as well in the whole, in the whole negotiation process.
Yeah, and Jonathan, just to answer your question in relation to, is business rescue appropriate when it comes to restructuring or getting the landlord to reduce the rental? That's exactly what we did in Camps Bay with the restaurant. We went straight to the landlord, said to the landlord, reduction in rental, landlord agreed, pulled out of business rescue. So, we say that I have a business can survive if I aggressively restructure. Well, that cries out for business rescue. That's what the engaged guys do. That's what business rescue is for. And then there's another question. Surely during COVID-19 at the moment, the usual legal requirements regarding business rescue and liquidation no longer apply. Quite correct. For instance, the time periods have been suspended. So the usual legal requirements have been shifted. They have been amended. But it would actually be the other way around. If we didn't have business rescue as legislation, I think they would have urgently promulgated legislation to actually do what business rescue is doing at the moment. When it comes to liquidations, though, I don't think I think the courts are going to be far more forgiving when it comes to the conversion of business rescue into a liquidation, or a liquidation in the first place. So it isn't business as usual, and I anticipate that the courts are going to be forgiving, because if they were to treat every application as they used to, well, the systemic risk is just heightened. So they've got to come to the party as well.
Well, it all comes down to a reasonable prospect assertion, Maurice. And because of COVID-19, so a company that previous to COVID-19 was ticking along and making a modest profit, and is now in financial distress as a result of COVID-19, the courts will surely rule that there must be a reasonable prospect of that company being saved or returned to a solvent going concern once the crisis has blown over. If the courts are, do not find that, then they have to find that the entire country, the entire economy will be done for. So what I'm saying is that the courts will have to look favorably upon challenges to the reasonable prospect assumption, and that's why business rescue is such a great what do you call it,
mechanism.
Mechanism, yeah. Business rescue is such a great mechanism, which is perfectly suited to this disaster we're faced with.
Diane, to answer your question, we can set up a one-on-one. Please, we encourage it together with your team to have. You are a small company. We're here for small companies. So let's set that up. You can reach out to us through info@cobra.org.za, or please email me directly, crespi@schindlers.co.za. Then Jane has asked who can assist in Franschhoek. We can assist in Franschhoek if you're based in Franschhoek. What we've arranged is, well, first of all, everything's over Zoom. The company's office is in Pretoria, but we do have people on the ground to assist you there. So if the COVID lockdown were uplifted, we actually got volunteers who reached out last week saying, please, 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 can they assist on a pro bono basis? One such volunteer is actually a director, ex-director of EOH, a very, very, very qualified person. Do not leave under a cloud. And that's the kind of skill set that COBRA has attracted. So around the country, whoever needs assistance, COBRA is there to assist. It's not unique just to Gauteng.
And yes, the rest of the question, all affected persons' negotiations are discussed and agreed prior. Yes, very much so. Prior to business rescue, yes, we'll discuss our strategy with you as much as possible, or potential strategy. And then during business rescue, this is why the choice of your choice of the business rescue practitioner is so critical. You need a business rescue. Remember, the entire board of the company ultimately reports by law to the business rescue practitioner. That's why it's so important to have somebody that will work with you, as opposed to just taking over and calling the shots themselves. That's why, yes, so find somebody, a business rescue practitioner. Your choice of business rescue practitioner is so critical. It has to be somebody you can work with, has to be somebody who is going to include you in all discussions and negotiations and key decision making.
Certainly. So guys, please set up those one-on-ones. There are quite a few of you I think need to. Let's make it more personal, and we really, really want to assist. And I can't think of anything better than in 6 months' time looking back, and we were instrumental in your business's success. So please reach out. If you want to have a consultation every day, we're there for you. So thanks to the panelists, thanks to everybody. If you're in the hospitality, tourism, restaurant business, please sign up for Friday. We're going to have some panelists. We're going to have some experts in the industry. We're in fact going to have a business rescue practitioner rather, who is in the restaurant business and has been for the last 20 years. So please join us on Friday. We'll see you there. Yeah, other than that, thank you very much. Thanks, guys. Cheers. Bye-bye.